to Knoxville, don't be late. Baker's Live, it's gonna be great. June 5th and 6th, mark your date at Dollywood, we'll celebrate. Meet Baker and more cool friends, live show magic that never ends. Come to Dollywood, feel the vibe. With great people there, it's gonna be a ride. Rides, fun, and meet and greet. Baker and pals, the crew's so sweet. Get ready for laughs, cheers, and thrills. Knoxville's the place, it's giving chills. Meet Baker and more cool friends. Live show magic that never ends. Come to Dollywood, feel the vibe. With great people there, it's gonna be a ride. June 5th and 6th, don't miss the fun. Meet Baker and friends, it's second to none. Baker and friends, it's second to none.
Good morning, good week.
I'm Jimmy. How y'all doing?
You know what we do?
Yes.
When did you first meet Maureen?
This is in the summer of 14.
And where did you meet her?
Good morning, good evening, good afternoon, wherever you are, whoever you are, what, if any, you might be. And what a start to the day. And my hair is annoying me. How are we all doing? Back with the Todd Mullis case. His civil suit to get a new bite at the apple to try and prove that he's innocent, that it was an accident, he didn't unalive his wife. I was very critical the first day. Second day, I also thought went very long. But yesterday, I think they finally got to some of the stuff that could potentially lead to a new trial. Someone asked me, "Oh my God! Oh 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 my God!" And they just zoomed in on it. Let's play last post for his hair, and now I don't feel so bad about my hair. Is Jimmy working on a lip or some seeds? Well, he's selling cars and banging wives. He's living the life. What do I think about it so far? So far, I think that there has been some elements braced that could potentially be interesting to look into further. Has he earned a new trial? Well, that comes down to the battle of the experts between the state ME, who I just felt like they sat and talked to her for 4 hours and didn't really get anywhere other than she was talking to the police, so she had predetermined that it must be been a murder. The lady yesterday who said, well, it could only be an accident, just because Jamie is so pro-defense, as she always is, I try to be a little more, there's holes you can poke and hurt explanations as well. Because I still have a hard time with the 6 holes and only 4 prongs. If it's enough, I'm not sure that you'll get there yet. I don't. The judge can wave it off and say, well, that's one expert's opinion, another has another opinion. It has gone through an entire courtroom. They chose to have the defense. He at that time participated in that defense. So I don't think we're there yet. I have to be honest and say, yes, there are some holes, but we also have to remind ourselves they have gone through an entire trial. He participated in that trial. He testified at that trial. So I don't think we're there yet. We have heard one witness who says it must have been an accident. But we heard a witness who said it couldn't be an accident. And you will take the bias you have and hear that one of them is trustworthy and the other one isn't. But in the end, I don't think it's enough for the judge to say, well, clearly the entire trial was a wash. I'm not sure that there's enough there yet. Yeah, do the frozen. Just let it go. Good to hear. I hope the chocolate helped you. Ineffective assistance of counsel is such a high bar, and he participated. And I think that alone will be such a monumental thing because he testified in that trial. And I think to the judge, they would say, but you all of a sudden thought your defense wasn't the correct one after you got convicted. And we know ineffective of counsel, you can be asleep at the table as long as you can say your name and the defendant's name and kind of remember what trial this is. You reach the minimum for effectiveness of counsel. So yes, there are elements that, and I didn't watch the first trial, so I don't know what evidence was presented at that trial. There are elements that for me sounds like, probably should have looked at that at the time. But in the end, it's kind of like the Arca guys and Trooper Paul. Who will the jury believe? I don't know. I don't know. And this is a special one because, again, it's a bench trial. The judge have read all of the papers around this. I don't... And so far, we have only been presented with the defense side of the case as well. So, of course, all the best things for him has come in now. All of the witnesses who's going to come in and testify that she was afraid of him and she was trying to get out of the marriage and he was threatening her and he clearly had a motive to do it. Will it change something? I don't know. I don't know enough about this case. I know there's a lot of people out there who he's clearly guilty, he's clearly innocent. Where I am right now is I'm not sure that there's enough there to overturn or at least send him back into court. Because so far, we are 4 days in. I've only heard one person say something definitively different. Then you can say, well, the ME and the police officer talk to each other. Happens every day. They had a lot of stress at the coroner's office. We've seen pieces of evidence go missing. We've seen pieces of evidence that multiplied while in custody. So I'm not sure he's gonna win it over yet. I'm just calling it as I see it, and if people get mad at me for that, that's fine. But You know me, even though someone said yesterday on Twitter I should have some blue pills, I'm passing out red pills. And I have to be honest, I don't think we have reached the bar yet for a new trial. Yeah, sometimes you just lose a finger. That happens. Did the testimony include injury to hand consistent with corn rake? I don't understand that question. There is no hand injuries with a corn rake, but there was injuries to her hands that the biomechanical engineer claimed was from when she fell over. But again, we have had one good witness for the defense so far. Let's see where it goes. Why can't I type fry your banana in a super chat? Which word did you ban, Baker? Where is my member chat? Your member chat is in Wisconsin, outside of Jamie's house, in one of her mailboxes that's shaped like a trash can. And why fry your banana? None of these words are banned, and you are a moderator, so you should have more leeway than all the rest. Yeah, and again, I know some people think that we should be, well, he's clearly innocent. This is a court of law. It's not magic time. It's the same thing with the Karen Reed case. Clearly innocent, yeah, but it just doesn't matter. If the state want to prosecute you, they can prosecute you. If you want a new trial, well, you have to swing the levers of justice and swing it hard, because the state have all the cards. Brandon sent a super sticker next time. Is that a threat, Brandon? But thank you for threatening me with a good time next time. Hey, Linda C. And another super sticker of a... Oh, you're so sweet. A chicken with hearts for eyes. I think it's the Goldslager from yesterday that's kicking in. Because those stickers could be from a high school girl. Not that there's anything wrong in identifying as a high school girl, Brandon. Hey, Holly Mac. It's a lemon. That's not a lemon, that's a chicken. Maybe it's a lemon. Why does the lemon have arms and a beak? What GMO hell did that come from? Have you seen Karen Reed supporters raise 25,000? Amazing. That was a great birthday gift. And at this super sticker. This is no lemon, but it's a yellow hand doing the rock on symbol. Yeah, sadly it's not the shocker. That's one finger too little for it to be the shocker. It should be a shocker emoji. I'll probably get in trouble with YouTube if I put up a shocker emoji. Hey, the space between. But I don't know, am I totally wrong? What do you feel? Do you feel that we have had evidence enough to totally overturn the trial and he should get another bite at the apple? Again, remember, they have had a trial. You have heard 4 witnesses so far. So it's not what you read on Reddit or in the newspapers. It's what's presented in court. Do you believe the judge will overturn it? Because
Good morning. Are you
that's, again, one of the things that we kind of tend to do because we know so much background on some of the cases. So we bring all of that into the case, but we have to rely, kind of like we do when we find people guilty or innocent, what has been presented at court.
ready to proceed, counsel?
Yes, Your Honor.
All right, you may call your...
On what basis presented so far? I have a hard time seeing how you would overturn everything just on one witness claiming that it must have been an accident, when everyone else keeps to the same story. I'm not saying you're right or you're wrong. I'm just saying remember we did have a trial. A jury found him guilty. So I have a hard time seeing why that this judge will say, well, they were wrong. We have to factor that into it as well.
First witness.
Applicant calls Sean Castle.
All right, Mr. Castle, take your time, come forward and have a seat in the chair to my left whenever you're ready.
Yeah, I'm pretty writing the defense as well. And Sleuthy kind of do. Going in, haven't seen the evidence. Five hat. I don't know what the standard is, but I would convict him on the evidence presented. From what I heard so far, I don't think the judge will over it. I don't think the judge will give him a new trial. Overturned on a hired gun, no chance. I don't even get why they are throwing good money on our time after bad. That's yeah, I think they need a lot more technical evidence than just that one lady, and she did well, but I think she was a biomechanical engineer. I think they need an ME as well to tell us where the state ME went wrong. I don't know how much she have read before, but then it's up for the defense to tell her what happened. Also, it's my position that it's absurd to think a judge can know whether pieces of information would have made a jury vote differently. We actually have something in Denmark called a Rule 89. That is, if you have been charged with a crime, and between the time you are charged with that crime have been convicted of another crime, and then we have found you guilty, and then at our sentencing, we would have to go back and try and see what would they have added at the first trial. So it actually is something you do, at least in Denmark we do it, where if someone had gotten 6 months between the crime and our trial, and we are giving them 14 days, would they have added those 14 days to the 6 months, or would they have said, no, it's nothing, it'll just be 6 months? So we have to tackle that, and judges have to do that as well. You also have when people are reoccurring criminals and stuff like that. So judges have a lot of expertise in evaluating stuff like that. And but my biggest problem is that they changed the narrative totally, and he testified. So, but I didn't see his testimony, so I don't know if he supported that someone else did it and maybe pointed fingers.
So the testimony you're about to give will be true and correct.
Yes, ma'am.
All right. Microphone is on, so you should be all set. You can adjust the chair if you need to.
Hello.
Whenever you're ready.
Good morning, Mr. Castle.
Morning.
Can you please state your name and spell your last for the record?
Sean Castle, K-A-S-A-L.
And Mr. Castle, what is it that you do?
I am a digital forensics expert and a network security consultant.
What?
Network security consultant.
What does that entail?
For the past 15 years, I have served as a consultant in the network security industry, specifically in the IT markets, helping dealerships build networks, telephone systems, and helping their network security posture, as well as serving as a...
Panella, we know it's just because you don't want to come meet Jamie next week. It's okay.
Digital forensics expert. I have spent a lot of time learning, teaching, and instructing.
I like that the defense had demonstratives, but when I see the pictures of the corn rake, doesn't it have curved prongs, or are they straight prongs? Because I see them as curved, and that would quite change the way it would enter the body, because it's kind of stiff. Snow Canton as corn. Just because you present first doesn't mean we need all the irrelevant cumulative evidence. Make the goddamn card. That's the thing I've been saying, and people got mad at me that they allowed to talk. They are absolutely allowed to talk, but you need to tell the judge what is different from the first case. And I thought they wasted so much time. And you could tell by the judge's demeanor yesterday, she kind of went into full Bev mode saying, remember, there's no jury here. Don't put on the show. Just give me the facts. And I think the defense, especially the lady, the angry lady, not the smiley lady, she really needs to be very concise. Her questions are so weird and so long and so roundabout, and she asked them 5 times. She did the Lally thing yesterday where someone said something and then she asked them about it. Listen to your witnesses.
Enforcement and the sciences behind digital forensics and network attribution.
Does this include analysis and
Yes,
interpretation of the digital evidence?
It does. It is the process of collecting, analyzing, and building threat reports as it pertains to evidence contained within digital devices.
So you have professional experience in digital evidence interpretation and investigation?
I do.
Can you tell me a little bit about the training you have in the area of digital forensics?
Yes. So in the industry of digital forensics, there are several software titles that we utilize on a daily basis. They are annual subscriptions for the licensing on those titles. And as a part of the renewal process, I purchased the training packages that accompany those titles from Cellbrite, Magnet Axiom, Oxygen Forensics, and Xero FTK. I also teach. I did my adjunct work at the University of Nebraska-Kearney under a PhD, Matt Miller, and I also am a returning guest lecturer and instructor at the Institute of World Politics in Washington, D.C., where I teach specifically in the area of network attribution and threat intelligence as it pertains to signals intelligence, social media intelligence, and open source intelligence.
So you instruct with the military?
I teach graduate students who are going to be employed by intelligence services such as CIA, NSA, and I also instruct law enforcement at the University of Nebraska-Kearney. I teach them means of correlation of data points and give them an understanding of how to build context within correlation of data.
Mr.
It's taking independent data points as it pertains to the evidence contained within devices.
I just boosted it, so beware. At some point, they'll find the volume button and blow our ears off or turn it off.
Building timelines and understanding how all of those data points come together to understand the full narrative of events or patterns.
Mr. Castle, have you provided any previous expert testimony?
I have. I've testified in state courts, federal courts, and military courts.
Have you ever been appointed as a special master?
I have. A couple instances of which I was appointed to a district court judge. The situation surrounding that was the Attorney General's office of the state of Nebraska had received privileged information and pertains to communications between their client and the attorney. So my role was to be a custodian of the data and assist the judge in parsing out that privileged information so that the AG's office could have a comprehensive report of all of the other data contained within the device.
Have you ever been disqualified as a digital forensics expert in any court proceeding?
No.
Mr. Castle, can you tell us what digital forensic evidence, what that term means?
The science of digital forensics is the ability to collect, maintain the integrity of, and analyze artifacts in digital devices such as mobile phones, tablets, computers, servers, and cloud data sources.
Are there standard operating procedures for digital forensics?
Yes, there are industry standards as defined by organizations like the National Institute of Standards and Technologies, as well as the companies who build the digital forensics tools that we use have best practices and standards for procedural aspects of collecting, maintaining the integrity of, and doing the analysis of the data that are contained.
Would this include the investigation and interpretation of the data?
Yes.
Do you follow these standards?
Yes.
Mr. Castle, were you retained by counsel for Todd Mullis?
I was.
And did you examine any electronic devices in this case?
I did.
How did you physically examine the data?
I was invited down to the Sheriff's Department in Delaware County to do my own independent collection of multiple devices on site there in September of 2022. And I also visited the Mullis family farm to collect some devices there as well. Specifically on the mobile devices, my assistants and I collected through multiple extraction processes those mobile devices to also include a network security recording device for cameras, which was located on.
So how many people have unalived with a keyboard? Well, probably more and more if how people are mad they have to go back to offices. The ties are bent on top, but a large section of tine is straight and would enter straight in. Yeah, but then you would still have. So it's kind of like this, right? But then the wound, you wouldn't have straight wounds, and that's kind of what I saw in the rendition yesterday. Then you would have a lot of tearing because of the bent tip. I don't know. I'm just asking questions.
Mullis family farm, and also a satellite-based Dish Network TVR set-top box.
Hey, Jemima.
And multiple laptops. I think there were 2.
What do you do first when you examine an electronic device?
It depends on the device. When it pertains to mobile devices, the first thing to do is to isolate that device from any connected network, placing it in airplane mode and making sure that Bluetooth and other similar network connectivity options are turned off, or by placing it in a Faraday cage or bag to make sure that it is unable to talk to any networks for fear of data corruption. At which point we connect those devices to the laptop or machine that we're using to extract that data and process it for further analysis. With laptops, it requires pulling the hard drives out of the laptops, connecting them to a forensic write blocker, which inhibits the ability to modify, tamper, or corrupt the data contained on that laptop, and do an image of the hard drive for further processing later. That same process is also followed with the hard drive contained within the camera security network video recorder, and as well as the set-top box from Dish Network.
But that's just a very, very, very hard thing to prove. Because in the end, it's his responsibility that the defense is the way he likes it. They can't force him to choose a different defense. We see it all the time that lawyers say, well, we have to withdraw because we don't agree on the tactics. We saw it with Ty Treehouse. We saw it with Sarah Boone. We have seen it multiple times. I think Diddy have just lost a lawyer because of the strategy. So I think the problem will be he didn't make a stink then, and then all of a sudden he didn't agree. He might not have agreed at that time, but he never told anyone. And that's a problem. Yeah, these are the guys. Everyone thinks that the CIA agent look like James Bond. These are CIA types. Hey, Kelly.
Can you explain what exactly you mean by extraction?
It is the process of collecting the data contained on the hard drive or the memory within a mobile device or laptop. There are multiple extraction methods available to a digital forensics investigator. With mobile devices specifically,
it's always great to have respectful discussion. That's why I respectfully said that I don't believe that him claiming now that he was not agreeing at that time is enough to convince the judge.
Is logical, advanced logical, and physical methodologies available, both through Cellbrite and Oxygen Forensics. That process is similar in nature for both Android and Apple platform devices, and entails different methods of collecting that data within the device.
What software did you use for the phone and iPad extractions in this case?
Cellbrite UFED, which is a Cellbrite Universal Forensic Extraction Device. I actually licensed the title Cellbrite UFED for PC, which allows me to install that on one of my laptops, making it a little bit more mobile or portable.
Thank you, Kelly, for the pair boxing gloves super sticker
solution.
Can you explain the 3 types of extractions through Cellbrite?
Yes. The logical extraction process is a simple process of extracting the data as it exists on the file system of the hard drive contained within the mobile device. That is the same for both Android and iOS platforms. The advanced logical extraction process entails both a file system extraction and on the Android platform, an ADB or Android backup process. On the Apple Ecosphere platform, it would also entail an...
I just love that this police department still have all the the evidence so he can do his own extraction 4 years after the case. Don't they know you'd throw that in the trash so no one can get the metadata? But I would think if he swings at her, let's say the wounds would probably be messier, like more scrapes, cause again, if he took it out to hit her multiple, it's weird there wouldn't be more than 6. Yeah, and the lady yesterday had an explanation for why it could be 6. So then the state will have to bring someone back to say, no, doesn't make sense. No, this guy isn't the one who invented Cellbrite. This guy just bought the subscription, but he uses it. Allegedly 40 witnesses, and I think they have been through 6 so far, so it'll probably end somewhere next year.
iTunes backup method, and the physical process of collecting the data is very similar to the.
He had a good witness yesterday. I'm still not convinced. I'm fence sitting this one. I'll be the I don't know who's fence sitting. Tim Pool of this one.
Process of the hard drive contained within a computer, and that it is a bit-by-bit copy of the data contained on the drive within the device. The physical methodology is the most comprehensive and the best method to use. However, depending upon the device, the software version running on the phone, and the software version of the software that I use.
Yeah, and that's why I think her landing on it makes sense. Because I don't think you can. Again, we did the speed versus the speed times mass, and the force needed to penetrate. And I don't think, especially in an enclosed environment, that you could generate that amount of speed. But I don't know how heavy a hoe head is. The human head weighs 2.5 pounds. I hate that kid in that movie. So I think her landing on it, especially on a solid floor, makes sense. Because I don't think the acceleration of that hoe is strong enough. And I love that I can say hoe because it is a hoe we're talking about. And not the victim. She was just friendly to her neighbors.
Collect, it may not be available as a process.
After the extraction, did you do any analysis on the devices?
I did. I ingested the extracted information into Cellbrite Physical Analyzer, which is the software that Cellbrite produces.
Yes, it's because the state is wrongfully called Iowa v. Todd Mullis, which in reality it should be Todd Mullis v. State.
For that process. And I also ran these devices through Magnet Axiom, which is another forensic title available to me, and a tool that is commonly utilized both by private sector and law enforcement. Using both tools gives a better and more comprehensive overview of the data, as both titles have specialties, meaning that those software companies have spent their resources and money on specific areas of analysis.
Thank you, Carly Kramer, for a dog hugging a heart. Or maybe a fox. But thank you so much for the super chat.
And have special unique abilities within that software title. As an example, Cellbrite spends a lot of their research and development time finding ways to circumvent encryption processes utilized by cell phone companies, where Magnet Axiom has spent a lot of time developing ways and means to process the SQL-like databases and JSON files that make up the data constructed within a mobile device. So using both tools gives a very comprehensive overview of the data contained.
You mentioned some other electronic devices. Did you do extractions for those as well?
I did.
What software did you use?
For creating the disk image of the network video recorder for the camera security system and the Dish Network set-top box, I used FTK Imager to produce an EO1 format of the disk image. And for the analysis of the network video recorder for the camera security system.
Again, with her dizziness and the pills she was on, but I think they need to bring in someone to talk about that dizziness and pills. Because maybe she was standing on something and fell backwards. But it's also a very small room to fall, so she had to have fallen straight back. I don't know. I'm just here for the ride. No, we're still trying to figure out what the Axiom and Cellbrite he used to download the digital traces. Yes, I know that this is what they're trying to do, but I just don't think that if you only have one lady saying, well, it must have been an accident, that's enough for the judge to say, well, that's strong enough that a jury could potentially have reached another decision. But I don't know. I've never seen a case like this before.
I used the same software title that the law enforcement used, which was DME, DVR Forensics. It was the same title that the law enforcement in this matter used for their analysis.
Did you generate a report on your analysis?
I generated a couple of different reports. I will be specific of those. A general report.
We will get to it. They're not talking about it yet. They're just qualifying him as a digital forensic expert. He's the guy who will come in and say the Google searches happened at a different time, or it could have been anyone or something like that. He is... it's kind of like the Hustle Long to Die search.
Of my findings overall was authored, and then I also created individual extraction reports of the data contained within the different devices that I had an opportunity to do analysis on.
I would like to show the witness what has been marked as Exhibit 272.
Did you go and look it up?
Is it on your screen?
I do.
Do you recognize this?
But the problem is only 2 of them so far have been compelling. The rest of them is state witnesses that is very combative and doesn't change their story. So that and you could hear the judge yesterday. She was running out of patience with the Todd's team. So I think they'll have to sharpen up and get to the point much faster.
This is a current copy of my Circle and Vitae, noting my professional experience, training, presentations I've done, and some of my work history.
And you mentioned this is up to date, so there's no additions?
No, I believe this is the most current version.
And can you scroll down to page 4? And what is this, Mr. Castle?
This is the first page of the report that I authored of my findings overall for this matter.
Does the CV and report, or general report, fairly and accurate represent your work and experience in this matter?
Yes, it does.
Your Honor, the applicant offers Exhibit 272.
Any objection?
Yes, Your Honor. Beyond what has been referenced, this exhibit also contains an affidavit. The report and affidavit are hearsay, and in addition to that, the report contains what this witness, essentially credibility findings of this witness, speaking about other witnesses that have testified in this case. His credibility determinations and his opinions about the truthfulness of other witnesses is inadmissible, and the report should be excluded for that reason and because it is hearsay.
Would you like to respond?
Your Honor, this goes to what happened in the underlying trial as well as the evidence that was presented, and it is a full explanation of Mr. Castle's experience and his analysis of the data that he extracted and analyzed. It's about the weight and not the admissibility of the evidence.
272 will be admitted. However, the court will not consider the affidavit portion of that exhibit or give any weight to any credibility determinations made of other individuals if they're referenced throughout the report. Certainly to the extent that counsel is utilizing the report in any questioning of the witness, I would ask that you avoid any of those portions, please. You may proceed.
Thank you, Your Honor. Did you review any depositions or trial testimony in this case?
I did.
And who would that have been of?
The testimony and trial transcripts of former Deputy Travis Hemiseth and the DCI agent, Mr. Trebet.
Your Honor, I see the witness is reading from the screen. Is he reading from the report?
He is, and I can put it up on the TV if that's helpful. Maybe.
Did you also review the testimony and deposition of Ward Crawley?
I did.
Nicole, you can take that, Lisa. Did you receive and review the extraction and digital discovery evidence from Mr. Mullis' criminal trial?
I did.
Mr. Castle, did you review the iPad that belonged to the Mullis family?
I did.
What browser was used on this iPad?
Wouldn't it normally... I don't think rakes, but rakes are not that common in I've heard people getting into combine harvester and they have a lot of those prongs in front of them. So I've heard about people get both impaled and going through the thresher and losing limbs is quite common, I think. But it's been a good long time since we have a raking.
Primarily the Safari web browser.
On this particular device, did the Safari web browser default to Google searches?
The Safari web browser had the Google search engine as its default search engine.
Did you review Mr. Hemseth's testimony regarding the iPad?
I did.
And do you recall that his testimony about the search history on the iPad was falling off?
I do recall that portion of his testimony.
Was this correct?
No.
And why is that?
I'm going to object. This is going into credibility determinations. He can testify about his own findings and whether, and the court can determine if they are consistent with the underlying trial testimony.
May I be heard, Your Honor?
Go ahead.
This is not a credibility issue. This is about the actual issues and what was actually on the iPad and the evidence that should have been presented at Mr. Mullis' trial.
I agree. Objections overruled. Do you remember the question, sir?
Could you restate, please?
Yes, you were about to explain the search history of the iPad falling off.
Yes. Upon visual inspection of the device, there would be a list of most recent searches that a user had done on the device. But upon the extraction and analysis of the data contained within the iPad, it reveals a longer history or a more comprehensive understanding of all the searches that were conducted on the device.
I have a friend who has she has several horses, and they had one at the stables where you keep. She rents place for the horse, and a girl got kicked by one of the horses, and she got kicked in the shoulder, very close to the face, but she just did the. Took her face away so she didn't get it in the face, but one of the, you can break the neck. I think she broke her shoulder or it got kicked out of the socket or something, but imagine getting a full force kick in the face.
Can you explain what it would mean for searches to be falling off?
Visual inspection of the device, when tapping in the Google search area, it would show the most recent searches conducted by a user of the device. And that would be a short list, just simply because the screen is only so long and it would only represent those most recent searches that were conducted. But that does not inhibit or restrict the memory of the device or the number of searches that were actually conducted on the device itself. That would be revealed upon the extraction and analysis of the data itself.
So the evidence would still, or the search history would still be available?
In two different locations, one on the device and also as a part of the subpoena offered to Google for the comprehensive search history.
Were you able to determine when the iPad was first activated?
I believe I recall that in August of 2017, the first user activity demonstrated on the device was a connectivity to a wireless network, representing the first viable activity recognized on the device in its activation time period.
Is there a way to determine how the iPad accesses the internet?
Yes, the Apple ecosphere keeps a fairly comprehensive system log that demonstrates the network traffic that leaves or arrives on the device via its network interfaces. Those network interfaces being the WLAN interface, which would be the cellular radio on the device, or the Wi-Fi radio interface for standard Wi-Fi network connectivity.
Can you have a cellular data plan on an iPad?
There are a couple different models of iPad. One of those models does contain a radio that is capable of 3G, 4G, and now more modern 5G cellular data transmissions.
Are you aware if the Mullis family iPad had a cellular data plan?
Wasn't there someone in Britain who were drunk and fell out a window and landed on one of those spiky fences, where it went through the stomach and they only survived because they were drunk? I think that was... Did I imagine that? I think that was a case someone impaled themselves on one of those spiky fences, but survived because they were drunk.
It had a radio that was capable of cellular network traffic.
On the world level, it's that mining, oil workers, and fishermen that has the most dangerous jobs.
The time frame in which it had a data plan attached to it was determined later.
I would like to show the witness what has been marked as Exhibit 256.
Well, you don't have to pay extra for that one.
Mr. Castle, based on your experience in this field, is this a document that you would normally see?
Yes.
And do you often see activation plans in your work?
As a part of network threat attribution, one has to correlate multiple data points, one of those being subscriber data, to gain an understanding of the traffic that may have arrived on a device, the IP addresses associated with that traffic, and the data plans connected to them. Yes.
Your Honor, the exhibit is being displayed. This was an issue yesterday as well, where exhibits are being displayed where they haven't been admitted. Thank you.
It's a bench trial. It doesn't matter that they display it. It's the judge is there. Come on now.
Did you use this document to reach your opinion on whether the cellular data was activated?
It was one of the data points that I used, yes.
Counsel, and I guess I would just say, I mean, with regard to the displaying of the exhibits, again, this isn't a jury trial, and so it doesn't really matter to that end. Normally, we wouldn't want them displayed because a jury would be seeing them, but to the extent the court is the fact finder, that isn't a concern in terms of what's being seen. Obviously, we have spectators and the media viewing, so there is that, but it isn't those spectators or the media that will be the fact finder in this case. So just want to note that for the record.
And thank you, Your Honor. One reason I point that out specifically is some of the exhibits that have been filed have unredacted personal information, social security numbers, minors' names. So if it's up before I have a chance to open the exhibit, it's difficult for me to determine.
Well, yeah, and the issue of redacting information is certainly different. There shouldn't have been anything filed with unredacted information. I think there's only been one exhibit that we've talked about that needed to be filed at a higher security level. So that is something that should be brought to my attention. So thank you for that. All right, go ahead, Ms. Steenson. Sorry for the interruption.
That's okay. Thank you, Your Honor. Does this appear to be an activation plan from U.S. Cellular?
Yes.
Is the phone number the one, on the phone number listed, the one associated with the Mullis family iPad?
Yes, it correlates to the telephone number represented in the Cellbrite extraction report.
And what day was this plan activated?
I believe it was on October 12th of 2018.
Your Honor, the applicant offers Exhibit 256.
Any objection?
Based on prior agreements with counsel that we will not require U.S. Cellular to come in and lay foundation, I have no objection.
256 is admitted.
Mr. Castle, do you know when when planting is generally is?
Objection. This is the foundation.
I sustained.
Were there email accounts connected to the iPad?
Yes.
Is there evidence on the iPad that links to Todd Mullis 76 Google account?
Yes.
Is there evidence on the iPad that links to Mullis RN Gmail account?
I'm sorry.
All withdraw.
Okay.
That second part of the question?
Yes. Is there evidence on the iPad that links to the Mullis RN Google account?
Yes, there are artifact evidence of both accounts on the device.
I think it's the first time he's testifying, so I don't think you've seen him before.
And is there evidence on the iPad that links to Amy Lynn 5810 Google account?
I did not find any artifacts or evidence of that account being linked.
Mr. Castle, you mentioned earlier that you reviewed the cell phones in this case. Did you analyze Todd Mullis's phone?
I did.
And what type of phone was this?
It was an LG older style flip phone.
During the course of your
I had
review of
an
the digital
LG. I
forensic
like
evidence,
my
did you review
LGs.
Todd's U.S. Cellular records?
I did.
I would like to show the witness what has been previously marked as Exhibit
I can't get
373.
LG phones in Denmark anymore. I had one that was curved at the bottom. I really liked having that.
Can you tell me what this document is?
It appears to be a phone record of a device in a billing period noted. This appears to be the phone records for Todd Mullis' phone.
Are the last four digits of Todd's phone number 1114?
Yes, as represented in the document.
Are these the records that you received from the state?
Yes.
The applicant offers Exhibit 373.
Any objection?
Your Honor, the only objection I have, as was stated in our preliminary objections, is there is highlighting added by Mr. Mullis' counsel on the first page of the exhibit. But beyond that, in agreement, consistent with our prior agreement about the U.S. Cellular, I have no other objection beyond that.
373 is admitted with the understanding that the highlighting, I guess, was not original to the document.
Yes, Your Honor, and I believe there has been another version filed without the highlighting in it.
Okay, thank you.
And you can take this down. During the course of review of the digital forensic evidence, did you review law enforcement's extraction of Todd's phone?
I did.
I would like to show what has been marked as Exhibit 353. What is this, Mr. Castle?
And this is a page that was a part of the extraction report of the phone, Todd's phone specifically.
And how is it that you recognize this?
First, it notates the extraction report and model number of the device up at the top, and it was also labeled Todd's phone. And as far as the data contained from the report, it represents some sent and received communications.
The applicant offers Exhibit 353.
Any objection to 353?
Minimally, Your Honor, there's some handwriting on it. If additional foundation can relate, just the handwriting where it says Todd's phone, et cetera.
Ms. Stinson?
Yes, I believe that this. Yes. Did this? Did this come from defense counsel's file?
It did. It's not my handwriting specifically on the phone that, as far as the notes on it. I recognize the report as a result of the model number of the device and the communications on it.
But this is what you received?
Yes. Minus the handwriting.
Does that address your objection, counsel?
The good old Blatty Impaler, as they
I'm
call
fine
it.
with
in-
it being, Your Honor.
Right. Again, 353 will be admitted with the
In the
understanding
books.
that The handwriting, I guess, is not relevant necessarily to the exhibit.
Mr. Castle, did you analyze Mrs. Mullis's phone?
I did.
And what type of phone was that?
It was a smartphone with a larger screen, a more modern device.
Are the last four digits of the phone number 5675?
I believe so, yes.
Did this phone have access to the internet?
It did, which was in contrary to Mr. Mullis' phone, which the flip phone had internet capabilities, but there was no artifacts or evidence of any internet usage. Where on Ms. Mullis' phone, it did have a web browser that represented artifacts and evidence of web history to include social media.
Would this also include Facebook?
Yes.
So you indicated that there had been internet searches on the phone?
On Ms. Mullis' phone, yes.
Was there any email accounts connected to Mrs.
There were
Mullis'
multiple
phone?
accounts.
Is there evidence on the phone that links to Mullis RN Google account?
Yes.
Mullis RN Google account?
Yes, there was.
Is there evidence on the phone that links to Amy Lynn 5810 Google account?
Yes.
Is there evidence on the phone that links to Todd Mullis 76 Google account?
Yes.
Was there a recovery number on the Todd Mullis 76 Google account?
There was.
Can we get foundation for what the recovery number is?
The objection's overruled. The answer will remain in the record. Go ahead, Ms. Steenson.
Why is he so afraid of the technical evidence? He has a lot of objections. More like chicken book.
Can you tell me what a recovery number is for a Google account?
When setting up a Google account, Google wants a phone number that can be utilized to recover the account in the event of a forgotten password or a security breach, so that they can validate the identity of the user, so that they can have some means of validation that the end user is who they say they are, and have the ability to then get back into the account in the event of its lock or password forgotten scenarios.
So you would be able to reset a password for a Google account through a recovery phone number?
Yes, or offer it as a means of two-factor authentication.
So you mentioned that there was a recovery number linked to the Todd Mullis 76 Google account. Whose number was that?
It was the number associated with Ms. Mullis' phone.
Briefly on the Mullis RN Google account, did you review the search history from this Google account?
I reviewed the search history both on the device and as a part of the subpoena reply from Google.
Did you notice that the Google account included searches about cabins?
I did.
Over the course of your analysis,
Hey Jamie, have you searched any cabins today?
Probably.
Probably.
No, I'm not cabins. I'm not looking for cabins.
You're not a cabiner.
I like them.
Scott Young fell 60 feet from his luxury London apartment and impaled himself on wrought iron fence. I knew I have heard something about it.
Ew. That would suck.
Yeah.
this is in the forensic digital evidence of this case. Did you review Mrs. Mullis's U.S. cellular phone records?
I did.
I would like to show the witness what has been previously marked as Exhibit 374. Mr. Castle, what is this?
This is a representative of some cellular communications and the telephone number associated with Ms. Mullis's phone.
And is this what you received from the state's discovery?
Yes.
I would like to admit Exhibit 374.
Any objection to 374?
No objection. Just, however, if we can clarify for the record that it's being received from the state through Mr. Mullis's counsel, but otherwise no objection.
374 is admitted with that clarification.
Jamie hunts and gathers aubergines.
What? Brandon, you're on one today, aren't you?
I think Brandon is a little bored with the case. And then he tries to get a little rise out of you, Jamie, because anyone who knows you don't like aubergines. You don't eat vegetables.
Ugh. Who would?
Mr. Castle, did you analyze Tristan Mullis's phone?
I did.
What type of phone was this?
It was also a smartphone with a larger screen or display and had internet capability and connectivity.
Were the last four digits of the phone number 1864?
I believe that to be correct, yes.
Were there internet searches on this phone?
There were multiple internet searches on the device.
And what types of searches were these?
There were searches for PC games, mobile device games, several multimedia searches, and searches for, very specifically, military sniper-style games.
And what other types of searches were there?
There was some, under the multimedia category, there were some searches for some adult-related content.
Jamie never listens. She's just here to be the pretty face.
And what type
Yeah, look
of
at it.
online games did you find?
World of Warships and other similar combat-style online games.
And when you say adult content, what is it that you mean?
Specifically pornography.
And were there searches for snipers?
Yes, it was one of the games that was searched for.
And what type of online games did you find?
World of Warships and other similar combat-style online games.
World of
And
Warships.
when you say adult content, what is it that you mean?
Specifically pornography.
And were there searches for snipers?
Yes, it was one of the games that was searched for.
Did you create extraction reports of Amy and Todd's text messages?
Yes, I created an extraction report.
So they searched his phone and he was playing World of Warships, boring game, and searching for snipers. Sniper Elite is a game, I think MG plays it online sometimes.
Was that his phone or her phone? Because I thought he said he had the flip phone that didn't have access
Yeah,
to all that
but I
stuff.
think the Google searches was from him.
Well, they never determined it. That's the whole like question, because they just assumed, I believe.
Yeah, but I don't know a lot of ladies who play World of Warships. I don't like it. It's very heavy bodied. There's a lot of pay to play in that game. Corn, I have never heard about it. I don't know what adult content is. But Sniper Elite is a great game series with some great kill shots.
Well, I guess I just
Both
need to
from Todd's phone and from Miss Moses' phone.
Oh, their son's phone. Well,
Okay.
wasn't he 13 years old?
At the time, yes.
Well, that's a young age to play pocket billiard.
I mean, is it?
Yeah.
I don't know.
Well,
I feel like that's the thing. Now that it's more like accessible.
Jamie, I don't know. How would I know what men that age does?
I just mean in this era now-ish, because it's more accessible than it was when like we were kids.
But still, 13, that's when you start to get urges.
As pertaining to the communications between those two parties.
I would like to show the witness what has been marked as Exhibit 307. Mr. Castle, what is this?
I want to
this is
see
an
the
extraction report
instructions.
of specifically SMS communications between Todd and I believe Miss Moses' phone, or Miss Moses' messages.
And
Moses.
did you do this extraction report?
I believe so. On the cover page is missing. That would give more detail, but from my recollection, yes, this is a report that I generated of the data extracted from the phones.
And besides the missing cover page, is this a fair and accurate representation of the data you extracted?
Yes.
I would like to admit Exhibit
He said that type of military-style games. It wasn't the sniper rifle that wasn't mentioned. It was the game that was military style.
307 into evidence.
Any objection?
Yes, Your Honor. I think more foundation needs to be laid about how this exhibit was created. It's been portrayed as communications and text messages between the two, but after, I believe, page 20 on my version of the exhibit that I was given, there's pictures, Facebook posts, all sorts of different things that I don't think were mentioned by the witness.
I think I heard the witness say they were SMS communications, so maybe we could have some further explanation, Ms. Steenson.
While you were analyzing Amy Mullis's phone, you had mentioned that she had Facebook on her phone. Did you analyze her Facebook account?
I did, and the reports that I generated of those devices may have contained more information than just the SMS or communications between the parties. It may have included other artifact evidence that was contained within the device for review by defense counsel.
Do you see these, yeah, can you tell, what page is this? Starting on page 19, can you tell us what these are?
These would appear to be social media posts or the pages represented on their social media containing images and communications or posts on those media accounts.
And is this from Amy Mullis's Facebook account?
If you was slow so I can validate the, yes, this would be from the Facebook account for Ms. Mullis.
Is Exhibit 307 a fair and accurate representation of the SMS extraction you did and also the Facebook post from Amy Mullis's Facebook page?
Yes, this would be an extraction report of her advice containing those items.
Your Honor, I would like to renew my request to admit Exhibit 307.
Any objection at this time?
Yes, Your Honor. May I briefly, while you're the witness?
You may.
Thank you. Good morning, Mr. Castle.
Good morning, sir.
Up on your screen, do you have the Facebook messages there? Can you look at the bottom of one of those pages in the bottom right? Can you tell me what you see there?
Counsel, I think you probably have to identify a specific page, and then we'll have to have.
I'm looking at page 19. In the bottom right corner, it shows a page number. Do you see that? Once she gets there.
Yes.
And what does it say?
It has a page number of a total number of pages noted there at the bottom.
And I believe it states page 877 of 1,453. Is that what you see?
That is correct.
And this total document appears to be 46 pages, including the SMS messages. Is that accurate?
Yes.
So there is not 1,453 pages from Facebook in this document?
In this document, it would appear to be an excerpt or a extraction of specific pages within that more comprehensive report, yes.
And then if you can scroll just to, can you see the top of that page, the very top line on that, on page 19?
Which line specifically are you wanting me to look at?
So right by the e-filing stamp, is the top of that consistent with something that would be printed off Facebook, or is that something that would be consistent with coming from a Celebrite or similar type of extraction?
Can you scroll down just a little bit so I see the bottom of the page? This would appear to be part of a print of a Facebook page. This specific page, not part of the Celebrite extraction report.
Thank you. Your Honor, I would object on foundation, completeness, and relevance. These two mesh of documents are unrelated, and I don't understand this exhibit.
Yeah, I guess, Counsel, do you want to respond to that? It's certainly the way that the exhibit is labeled, and I guess my understanding of what the witness did, it would appear that the first 18 pages make sense. I understand how those were obtained and where they came from. The remaining portion of the exhibit does seem to be cherry-picked pages from Facebook. Can you clarify that, please?
Just one moment, Your Honor.
Sure.
Yeah, that could take things out of context. Apparently on the
Mr.
son's
Castle,
phone.
you mentioned that you did an analysis on Mrs. Mullis's phone that included that she had a Facebook account. Is that right?
Correct.
And is it possible to download information from Facebook?
It is.
And how would that work?
There are multiple ways to acquire that data, primarily for the purposes of integrity. Facebook offers a process of a Facebook download in which they pull all the data from their multiple servers that contain account information, posts, messages, those types of things, and combine it within a single zip file that has a report of all that data the user may have posted or communicated via their social media. Secondarily, there are ways to scrape or pull individual posts and pages from Facebook from a computer. There's a couple of different processes that could have been utilized to acquire the information.
Is a portion of your report these Facebook extracts? Starting on page 19.
Objection, Your Honor. The witness has already testified that this is extraction. These are prints from Facebook. And I'm going to add an objection under 403 that the exhibit in its current form is misleading because the page numbers continually jump around.
This exhibit does contain a portion of the Celebrite report that I created.
Okay, I apologize, sir. Yeah. I mean, I guess I heard the witness say that these appeared to be pages that were printed from Facebook. It certainly does appear to be incomplete if we look at the page numbers at the bottom. So we're really dancing around that issue. So the objection is sustained for now.
Oh, Como had a little sly smirk. We can't come. Jamie, look at it today, the state of it.
Your Honor, I would like to offer pages 1 through 18 of what has been marked as Exhibit 307, the evidence which represents this.
It's getting worse
the extraction
day
of
by day.
SMS.
It is.
Any objection to that portion of 307?
Yes, Your Honor, only because this gets back to my original objection with the exhibit, that I believe additional foundation for how the, because I believe the witness said this is coming from 2 different phones, so I believe additional foundation of how the messages were combined would be beneficial.
Ms. Steenson, would you like to lay some additional foundation specifically with regard to the, I guess, combining of the information from the 2 phones for purposes of creating a summary on the first 18 pages of 307?
Yes, of course, Your Honor, thank you. Mr. Castle, can you explain how you created this extraction report?
If I'm allowed to look at the previous 18 pages, I can validate.
Why is he doing the chicken fingers?
Okay. This summary extraction report here specifically is from Ms. Mullis' phone, and is not a compilation of multiple devices. The first 18 pages are just the extraction report of Ms. Mullis' phone, and the communications between her and Todd.
I would like to remit or renew my request to admit Exhibit 307, pages 1 through 18.
Mr. Bakke?
No objection on that portion. Thank you.
The first 18 pages of 307 are admitted.
Mr. Castle, did you create an extraction report of Mrs. Mullis and Jerry Frazier's emails?
I created a report of the communications between those 2 parties, yes.
I would like to show the witness what has been marked as Exhibit 308. What is this, Mr. Castle?
It is an extraction report representing emails between the 2 accounts noted in the second column, Amy Lynn 510@gmail.com and Jerry Frasher 70@gmail.com.
What time period do these cover?
It appears to be November of 2018. Is there multiple pages to this document, just a single page?
Doesn't fill me with confidence that the defense team have to.
Mr. Castle, can you tell us how you created this extraction?
So for this report, I chose the email communications category within the Cellbrite application and extracted that data specifically into this basic document.
And is this a fair and accurate representation of the report that you created of the emails between Mrs. Mullis and Jerry Frazier?
As they existed on the device, specifically, yes.
I would like to request to admit Exhibit 308.
Yes, Your Honor. This was also raised in our preliminary objections. Many of these email communications, example beginning at page 3, states that the item was truncated due to length. I don't believe foundation has been laid as to that truncation of the emails. Additionally, it states that it contains body files. Those are hyperlinks that don't go to anything. So the messages appear to be incomplete.
Ms. Steenson, would you like to address those concerns, please?
Yes, thank you. Mr. Castle, can you go to page 3 of this report, please? Can you tell me what it means to have this what truncate means?
When generating the report, due to the volume of the data contained within that specific communications, it leaves the final portion of that communication off as a function of generating this report. The source data that the information was derived from is complete in totality. This report just simply pulls the rest of the data out of it. This is more representation of that the communications between these 2 parties happened, and this is a overview or summary of the initial communication between the 2 parties.
Your Honor, I would like to renew my request to admit Exhibit 308.
Counsel?
Thank you, Your Honor. I do object, and I'm going to object on 403 that in its current form, the emails, the truncated version of the emails are misleading, especially with the full content not being available for consideration. Thank you.
May I be heard, Your Honor?
You may.
The state has all of this data. This is just for, this goes to the weight, not the admissibility. We are asking for, this is just an example of it reflects what was sent between, but the state has all the underlying data, and if they want to cross Mr. Castle on this, they are willing to.
Counsel, do you agree that you have all of the underlying data that was used to create this report?
Yes, Your Honor, it's likely in the terabyte of information, or approximately terabyte of information that I've received. I don't believe it's a discovery issue. It's that the fact finder here is only getting partial. So I think if there's any specific email that needs to be referenced, it would be more appropriate for that full email to be admitted, not truncated partial summaries.
Certainly. I do think it goes to the weight to be given this particular exhibit, if any. 308 will be admitted.
Mr. Castle, can you tell me what UTC is?
It's Coordinated Universal Time Code. It is a universal accepted standard for establishing a uniform way of maintaining a timestamp globally.
Is this standard in digital forensics?
It is standard in network communications as well as digital forensics, a way of establishing a baseline timekeeping methodology.
What time zone is Iowa?
Iowa is in the Central Standard Time Zone, or CDT, Central Daylight Savings Time Zone, depending upon the time of year that it is.
What is UTC time in Central Standard Time?
It is minus 6 hours from the UTC time code.
And does UTC time change with daylight savings?
UTC remains unchanged. However, the offset for Central Standard Time is adjusted by the hour.
When it is midnight in UTC, what time is it in Iowa?
Non-daylight savings time would be 6 p.m.
Is it typical for extractions to be in UTC time?
That's how the data contained within a mobile device is represented, is in UTC time code stamping. It is an option within the software titles to make that calculation
No, they're talking about the cell-bright extractions from multiple devices.
or adjustment for Central Time or daylight savings time accordingly.
So there has to be a conversion from whatever uniform standard time is used?
Correct.
And the reviewer would have to convert to Central Standard Time or Iowa time or the relevant time zone?
The machine will automatically adjust those time code stamps accordingly, making it less prone to mistake or calculation by the end user or the analyst.
Did you review Mr. Hemiseth's testimony regarding UTC?
I did.
Was he correct that UTC is military time?
No.
Was he correct that UTC is Central Standard Time?
Central Standard Time is a time zone based on an offset of UTC, so no, it would not appear to be correct.
So the times and dates that Mr. Hemiseth testified to would be wrong?
Unless the offset was checked against the time code within the report.
Military time, isn't that what you Yanks call the normal way of looking at a clock? Because there's 24 hours in a day and you Yanks have to, because you can't count that high, you have to do it 2 times 12.
Yeah.
So military time isn't a time zone. It's just, oh, right now it's 1700 my time. Military time.
That's a big difference. Just testify to military time versus.
Yeah, if you believe that going by a 24-hour clock instead of a 2 by 12, a 2 times 12 clock is a time zone, then you shouldn't teach your kid how to use a watch. And just I can do the math. I am UTC +1.
That would appear to be incorrect.
Mr. Castle, did you review the Dish Network DVR system?
I did.
No, you weren't. That's the Brits. You came in like all the time. You come sneaking in when the Brits have done the hard work.
And did you do extraction?
That's why the Brits get to determine what time it is around the globe, because that's based on Greenwich, which is UTC.
Of this electronic device?
I did.
And this is the system from the Mullis home?
It is. The satellite TV set-top box was the device I retrieved and created a disk image of to do analysis on. I extracted specifically some log files from that device to do analysis on.
Based on your extraction, could you determine what programs were watched and stored on the system?
There are 2 log files specifically that will help an analyst understand both the listings that were available to be watched on the device and also the shows or movies that were recorded and or watched by the end users.
Can you give me some examples?
Yeah, there were a number of Arnold Schwarzenegger titles that were viewed, recorded, and watched by the end users. And
I don't have a 24-hour clock on my wall because I don't have a digital clock on my wall. But I have a digital clock on my wrist, and I can show you. And it, look, it's 5:02. Yanks. Well, we became a country yesterday, so we had to decide that we can't do math.
a number of History Channel shows to include Ancient Aliens, some presidential history documentaries, and a number of military-style historical documentaries.
Can you provide an example of some of the shows?
Counsel, would you like to narrow your question?
Yes, Your Honor.
But just because Brandon wants it, you can buy a 24-hour watch. It'll only have one dial though, so it doesn't show you. But this is a 24-hour watch. You can buy them. I win
Was there
again.
evidence of Sniper into the Kill Zone show from the Discovery Channel on the DVR system?
Objection, pleading.
Sustained.
Can you give an example of a Discovery Channel show that you saw on the DVR system?
Objection, relevance, and foundation.
Overruled.
I believe that there were a couple of log files extracted from the device that would represent the shows that were watched and recorded on the device. And if I could reference those log files, I would be able to better assist you in knowing all of those shows.
I would like to show the witness what has been previously marked as Exhibit 369.
I think I just
Amazing.
lost audio.
Yeah.
Yeah.
No sound.
Is it back? Is audio back? You can't hear it?
Nope.
Why the hell? Normally it'll come back. Still no audio?
No.
And can you tell me what this is?
There you go.
The daily schedule log is a log file that represents the guide. When you hit the guide button on the remote, this would show you the shows that are available to be watched or recorded on the device.
And how is it that you recognize these files?
They're documented on the Dish Network website as to gaining the understanding of what those files represent.
Is this an accurate representation of the information you extracted from the Dish DVR device?
It is.
And just for the record, to be clear, this would be a portion of the extraction you did on the DVR system?
Yes, it is very specifically 2 files contained within the hard drive of that device.
I have a 24-hour watch.
So if there is a show or something listed on the log file, what does that represent? What does that tell us?
It was a
why
show
you have
that
to
was
sign a peace
available
agreement
to be
with
viewed
1814
on the device
after they burned the White
as far as
House.
programming that was available at that time. And a good way to correlate it would be to compare it to.
But the clock never says 24, it says 0000. Just so Brandon knows. When he comes to Europe and sees a digital watch and they don't say, where's the PMs?
Another document that would be representative of the shows available to be watched, such as a TV guide or a newspaper listing of TV shows available.
And I would like to request to admit Exhibit 369 into evidence.
Any objection?
Yes, Your Honor, I'm going to object on relevance and foundation. The witness has already testified that this is only a portion of the extraction. Additionally, this file is comprised of, I'll say computer language instead of gobbledygook.
What? I take computer language over gobbledygook. That's some way to say it. And yes, I think the defense team, or not the defense, his team seems very unprepared. They're constantly yippity-yapping. Yeah.
So I don't see the relevance or how this will aid court.
Your Honor, may I be heard?
You may.
Your Honor, the state has the underlying data for this extraction. This is just a portion of the extraction is quite large, and it goes to weight and not admissibility. This will go into explaining later on the digital, correlating with the digital evidence that was presented at Mr. Mullis' criminal trial.
Do I understand correctly that this is just a listing of shows that were available through Dish to be watched? I mean, not necessarily shows that were watched, correct?
There's 2 files here. And one of them is, as you say, it's a list of files that could be watched. The first portion of this report were the shows that were actually watched or recorded by the device.
And how do I tell that by looking at this exhibit?
So at the top of the page of this particular exhibit that we have open, where it says daily log, that is the file, the shows that could be watched, like the guide part of it. The first part of this file, which was the .back file, which...
Right now, the defense have to pick up the signal. You're losing the judge.
Comprises of pages 1 through... The catalog.back up at the top right there that you see indicates the shows that were recorded or watched, and that comprises of pages 1 through...
Your Honor, while he's looking, I'm going to add an objection on calls for speculation because I don't see anything in this that indicates when or if these were actually watched.
Well, I mean, that's my next question, is the date. I don't remember that there was a specific date provided.
There's the end of the back file right there. So everything preceding that daily log file portion of this report were shows that were watched or recorded. To correlate the date of the actual viewing of those shows, the TV guide listing for the time period of these shows in question would represent those timestamps.
Yeah, that means that they're not presenting it in a way that works for her. They have to do something else. Especially because it's not just the objections that she says rule over rule. She's actually interjecting that she doesn't think they presented in a good enough way. And I really don't like that they're constantly doing a crosstalk at the table. It seems like they're unprepared. I think the witness is really good, but there's the problem that there's too much information. He needs to... it's kind of like the guy in the Karen Reed case talking about the phones. Probably the smartest guy in the room. I didn't get one word of what he was saying because I didn't understand it. And that's the problem when you have experts. You need to talk to the stupidest guy in the room.
Yeah.
Because if I can understand it, the rest of the world can understand it.
I think a lot of the problem too, I think with me especially, is that we don't know what they presented in the first trial. So, because he's trying to obviously counteract that. And it's like, I can't be like, oh yeah, that's crazy because at the first trial they said this, you know what I mean?
Yeah, but still, this judge wasn't presiding over the first trial, so they are presenting her. But why do I need to know what could be played on October 6th, 2022? If they want to imply something, then tell me what was watched on October 20th,
We're probably
2022.
getting to it, but the state keeps objecting to relevance and, oh, this
Yeah,
is
but
incomplete.
Jamie,
and this and that.
I understand why they're objecting. The judge clearly doesn't follow where they're going. So I keep throwing. They just got a lot of pages thrown out because they didn't put in the correct format on the Facebook stuff. They only had the first 18 pages of text messages. All the Facebook stuff was thrown out. So I would keep objecting because clearly the judge is on the same side as us, that we don't understand what's going on. And again, why are you giving me the, what is it called, the TV, what was that little pamphlet you got back in the day? I just need to know if someone was watching how to get away with murder, or was Googling, if I kill my wife with a rake, how do I make it look like an accident, allegedly? So it's a spreadsheet. How difficult can it be? Well, if you put too much into a spreadsheet, it becomes, it's just overload. No idea. TV guide, yes. Facebook is still a play. No, because she said the first 18 pages is accepted, but because they couldn't tell the Facebook messages, even though they had the underlying, she didn't allow that in.
Okay, well, the next problem we have is I'm looking at what is page 14 of this exhibit of the document that was uploaded, which does not appear to be the same page 14 of what I'm seeing maybe on the screen. So let's go ahead and take our morning break at this time and see if we.
That's another big problem. If your evidence doesn't add up with what you have given the judge, because and again, I think this guy could be good because I think he's doing a thorough job, but again, he's an expert. And if they ask him, hey, can you do an extraction of the Facebook conversations between this and that? Yeah, sure. And he'll do it, and he'll just put it in a file. It's the defense job to make sure that, not the defense, it's Mullis's team's job to make sure you dot the I's and cross the T's. And it seems like they're not prepared. And that's why I think bringing Alessi on with the Karen Reed team was a good idea, because he seems to understand how to do technical stuff. Because technical witnesses can be very good and they can be very bad. Because it depends on how you can get them to present the data. Technical evidence is mostly for nerds. And the jury doesn't understand any of it, and most judges doesn't either. So you need someone who can present it in an easy, digestive way, so you don't have these incidents. Because if you give the state an option to object, they'll object. And I don't know. I don't think they seem prepared today. They were really good yesterday with the demonstratives of the rake and the torso. Today, this constant tap, 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 tap. It seems like they're not sure what they're presenting. Jimmy isn't. He was yesterday. The state is being petty. They will be that every time. This is a quick review of all the data to make it easier for testimony, so it looks like they need to get their binder in order. No. The defense needs to get their binder in order. If the judge upholds the objection, then it's the defense fault. It doesn't matter that you like the defense or you hate the defense. The rules should be followed, and as long as the judge upholds the objections, then they have a problem. And I feel like I don't know if they're trying to get something in there. I can't see what they could. I don't know. But a report based on all of the communication, yes, it should clearly be marked that this is bim bim. And we've seen that in other cases, but then they have to lay the foundation. And I just don't feel. Yesterday, I liked where we ended yesterday. Today, I'm not in high spirits. Because I really don't feel like they hit the ground running today. They make it too easy for the state to object. And the state will object. It's their job. Because the state don't want to give him a new trial. They want to do whatever they can to keep him in prison. That's their job. So don't give them the option to object. And sadly, it seems like this isn't good today. Hey, Jenny. Oh, the defense needs to get their binder in order. Yeah, they really need to narrow it down. The judge seems very fair. You could see she was really contemplating her rulings. It's not like a certain someone. You can file it and I'll look at it later. That's their job. They are a-holes. It's kind of like when people get mad when we have someone who's clearly guilty and the defense should sit down. No, their job is to defend the fella. Yeah, but they don't have to. Yes, they do. That's actually why we're here today, because the defense should always vigorously defend their client, even though he is the scum of the earth. Or lefty, as they call him, where Jamie comes from. Why isn't Jimmy there? And I haven't seen a snow-washed pair of jeans like that in a lot of years. Or is it a pair of... Is it jeans, Jamie?
What are you looking at?
This guy. Is it stone-washed jeans?
I don't know what they're technically called.
And
Maybe.
you don't wear a brown belt with jeans.
Oh, this is Iowa. Remember.
Yeah, only one flannel. I'm not sure this is Iowa.
The button-down shirt with the sleeves all pushed up. That's such a. Like,
How else are you going to get a farmer's tan? The job is not to keep him in prison. Yes, it is, because they believe they won the first trial fair and square, and he was put in prison for life. And they don't believe there is new evidence that proves he doesn't belong in prison. So their job is to keep him in prison. Look like dockers. Isn't that something you do in Britain?
Dockers? Aren't
No,
dockers
that's
like
docking.
khakis?
Docking.
Oh my God.
You know what the docking is in Britain, Jamie?
Why don't you tell me?
No, why don't you Google it?
No, thank you.
Come on, Google it, Jamie.
No.
Maybe have Iris ask someone. She's in Britain right now, isn't she?
Oh, no. Is she?
Wasn't she supposed to go over there yesterday?
I know she was supposed to go over there early, but I don't know how early. I thought it was only a few days early.
I think we need Iris to ask someone in Britain, what is docking and how do I do it? Dockers are a great brand of men's pants that are casual. Huh. Hello, Money G. Docking is the same in the US as Britain. So you go hang out in parking lots and get banged by randos as well, LDR. That's docking, Jamie. Rianne can tell you. She's from Wales.
Okay.
That's close to Britain. Ask Rock. Is it the same as soaking Mormon? I don't know what that is. I have to Google that. Is it in the middle of the woods? It's probably in a parking lot in the middle of the woods. That wouldn't be the worst thing in Jamie's Google history, sadly.
Oh my.
We Google a lot of stuff during trials.
I Google a lot of random stuff too, because I'm like, what is this?
Oh, you'll only be there the day before. Oh.
Oh yeah, I thought it was something like that.
Yeah. Please ask a British guy if he can help you go docking. Oh, no, it's not like that. No. It's, Wales is Britain. Well, I didn't want to assume. They took the morning break because the judge got a little, I think she got a little, she seems irritated with the Mullis team this morning. Well, it's kind of like where you just go to some random place and park your car, and then other people park their car, and so it's not like you know anyone. You just you're just offering up the roast beef sandwich. Well, Jamie turned it sexual, as always.
I didn't do nothing.
Hmm.
I'm innocent.
Oh, it's fun to go on random parking lots and offer off the roast beef sandwich. Well, Ginger. It can be in the parking lot or the woods, anywhere there's an audience who like to watch and take part. Yeah, it's not just the public smacks, it's public smacks with an audience. So we have, the mouse bridge that I've yelled a lot about. We paid 18 million to make a bridge for a mouse that never uses it. And we got that when we got the highway. And out there we have halfway between us and the big city, there's a rest stop where there's just a toilet. Sometimes when I brought the kids home and you're like, I just can't drive the last 15 kilometers. I need to take a wee now. And you would stop at that rest stop and you could just see those 3 cars with one of them shaking, and you thought, I'll just pee in a bush. I'll take the next off ramp and just pee on the side of the road. I'm not taking any chances on this rest stop. So no, in this court of law, Jamie is always presumed guilty until proven innocent.
How is that fair?
How is it fair that you always yell at me and you take away Brandon's membership chats? It's not. World isn't fair, Jamie.
It's very
How did we get to
justifiable.
talk about this? Someone mentioned dockers.
Dockers, like a dock.
No,
Not-
like a pair of dockers. Don't you talk about your longshoreman cravings, Jamie? Don't turn this sexual too.
What?
You have said multiple times that you need a good longshoreman when it's moist in the roast beef sandwich. I've heard you say it.
What? You.
Does the bald guy on the right have a headphone? No, this is our friend Baldy. Comb over. He's just, it's just sad.
It is a sad little patch of hair.
Well, it made us talk about something different than yelling in this case. By the way, I'll be ending a bit early because I have that stream with Julio at 1 p.m. So I'll probably go to noon so I can get some dinner and set up that stream, and then we'll come back to this. Probably going to be like an hour's discussion about the Coburger. So we will be on a slight delay, but we can get back in time. Public indecency is not the answer. Depends on what the question is.
Thank you. Please be seated. Go ahead and have a seat. All right, Mr. Castle, I just remind you.
Jamie, did you know my daughter has started watching these shows? Please keep all this stuff out of here. She's innocent.
You started it.
I did no such thing. Please refrain from making everything sexual. She is innocent. She's a virgin. Please don't treat her that way, Jamie.
That you remain under oath. And Ms. Steedson, I think we'll pick up maybe with some foundation questions with regard to Exhibit 369?
Yes, thank you, Your Honor.
All right, you may proceed when you're ready.
69.
Mr. Castle, in pages 1 through 14 of this document, you mentioned that this is the catalog.back files. Can you, are these is it your testimony today that these are the shows that were recorded and watched on the DVR system?
Objection leading.
Yeah, very leading.
This file represents content that was viewed, recorded, or watched even in part by the end users on this device.
Are you able to determine the timing that these shows were recorded and or watched?
With this document alone, and no.
How can you determine that?
Using correlation and aligning it with the TV guide schedule at the time.
And is this something that you typically do in your line of work?
Yes, using multiple data sources to gain an understanding of context and timeframes is important to understanding the scope of the whole thing, yes.
Mr. Castle, do you know what dates your extraction data covered?
Based on this document, it does not show the specific date range. I happen to know from the TV guide stuff what it may have covered, but this document does not show that.
When you extracted from this DVR, did you extract all the data from the DVR system?
Yes, it was a comprehensive collection of all the data represented on the hard drive, and these log files represent that.
I'm just waiting for them to get to what they're trying to bring out here.
Yeah, you just had a
Do you
15-minute
recall what
break.
date you collected this data?
Without referencing the forensic image I created of the hard drive the forensic image of the hard drive I created, I would have a hard time recalling that.
What year would you have done this?
2022.
And so the data included on the DVR system would be from whenever the service plan would have started to when you extracted the data?
I do not know what the log file's start date is. I just know when I collected the data. I don't know when the family chose to decommission or stop using this particular set-top box.
Like, was there something up with the DVR? Were they saying he was glitching? Like, come on, let's get to it.
Yeah. Yeah. As Brandon is asking for, what are we looking for? Man meat or how to rake a hole
Come back to
searches?
this issue.
It's rake with a hoe, Brandon. The other one could be misconstrued as something. Hey, Mouse, god eftermiddag. Technically, it's evening because it's after 5.
Did the state do an extraction on the dished DVR system?
I don't believe so. I believe they only received what the forensic image of the hard drive contained and the data from me and reciprocal discovery.
One moment, Your Honor.
Come on. I mean, I get that they're laying foundation, but
Mr. Castle, during your analysis of the Dish DVR system, did you look for History Channel TV guides?
Your Honor, I'm going to object at this time under as relevance in 403 that this is a waste of time because, for example, this document from the DVR says the Andy Griffith Show. If this witness is truly going to say that he can identify which specific iteration of the Andy Griffith Show was watched or recorded or whatever show it is, that there was no reruns at any point other than what could conveniently line up with their theory of the case, this is speculative and this isn't worth the court's time in the state's opinion.
What's the Andy Griffith Show? Is that a true crime show or?
No, it's just like it's an old show. Way back in the day.
Interesting.
Well, counsel, did you wish to respond?
Yes, Your Honor. This is providing contextual information about what was going on in the Mullis home and also provides corroborating evidence regarding the Google searches that were presented at Mr. Mullis's trial. The state at trial presented these searches without any corroborating forensic digital evidence, and we are now able to do so, which relates to the ineffective assistance of counsel claims in this instant piece.
If the lady next to her has to sit and mouth everything she says, why isn't she asking the questions? This is annoying.
I know.
Sorry.
Like, are they giving her something to do because she has nothing to do?
Stands, I don't have any information about the dates that would correlate to this information, so I'm having a really hard time connecting it to anything that could be considered relevant, at least without that information.
Come on, make it relevant then. If this is so relevant, come on, guys.
You know, again, if there's some further foundation that you can lay to tie that in some way, you certainly may do so.
One moment, Your Honor.
I never watched Andy Griffith. I just knew what it was. I knew of it. So I couldn't tell you what it was about.
I don't want to be grumpy or sound grumpy, but the defense not the defense, Mullis's team seems like they are rattled. They don't kind of like,
well,
they don't know where they're going.
Well, I don't like this. Honestly, this attorney that's asking the questions doesn't seem like she knows where she's going.
She seems like she's just
every time she has to stop and talk to the lady next to her to ask her like what to ask next. It's like,
yeah.
Then why is she doing this?
It's the wrong case to get work experience on. You can do that with a DUI case or something.
Your Honor, I will just move on for the moment.
Go ahead.
You can. Mr. Castle, based on your knowledge.
Yeah, but that's a really bad case because this guy, this is his last chance. And this could be maybe some very relevant evidence if they could tie some Google searches to something and prove that the state did a bad job or the defense team didn't provide enough evidence the first time. And then have a lady that constantly is next to her. That's
knowledge and experience. Have you done examination in internet browser-based
Google
searches?
searches were a big part of the first trial.
Yes.
So
okay.
What is the difference between a browser and a search engine?
A search engine is a program that is built by a content provider that will index and catalog web pages and the data contained on those web pages on the internet. A web browser is a program that is used to view.
But that's their job. They should expect that. But every time she says something, the lady next to her says, and that has nothing to do with the state.
The web pages on the internet specifically.
What would be an example of a search engine?
Google, Yahoo, Bing, web crawler, Excite, are all web-based search engines.
What is the example of a browser?
A browser would be
Safari.
Google Chrome, Chromium, Mozilla Firefox, Apple's Safari, or formerly Microsoft's Internet Explorer.
Let's talk specifically about Google. If you were signed into a Google account on a certain browser, does Google track your searches?
Yes.
It is an option that the user can elect for Google to maintain a comprehensive list of the searches that were conducted in that browser session, and is not necessarily device specific.
And is this typical?
It is.
Can you explain the difference between a device and an account?
A device is a physical piece of compute hardware, such as a tablet or phone or laptop. An account would be the user profile of the individual signing into that device. There can be multiple devices, there can be multiple accounts tied to devices, and synchronization options chosen therein.
What happens if a Google account is logged in on multiple devices?
There will be evidence artifacts of searches across multiple devices represented in the data that Google catalogs, and in the subpoena reply from Google, it will reflect multiple searches conducted on those devices.
Could two people be searching on two different devices on the same Google account?
Yes.
Would this all be saved in the search history for the account?
Yes.
So Google search history is not device specific?
It can be device specific, but it also can be tied to the user account tied to the device as well. So,
And the objection's overruled, the answer will remain in the record.
So if I understand you correctly, just because it is on a Google search history doesn't mean a certain device searched it?
I'm asking you to be a little bit more specific.
So if I had this phone signed into my Google account, and Tara's iPad was signed into my Google account, and I searched on my phone, could the search appear on Tara's iPad?
Yes, based on user synchronization options, absolutely.
Can you explain the difference between a search and web history?
A search is an end user typing a query of word or phrase into the search engine, asking for results. A web history artifact or evidence would be the visiting of a web page or the following of a link from those search results.
Did you review Mr. Hemisath's testimony regarding Todd Mullis 76 Google account?
I did.
Do you recall him saying that there was no evidence of Todd Mullis 76 Google account on Mrs. Mullis's cell phone?
I recall that.
Was that accurate?
No.
Were there indicators that Todd Mullis 76 Google account was tied to or connected to multiple devices?
Yes.
And which devices were those?
The messages, no, he said it was between two Google accounts, and that he had downloaded multiple devices.
The iPad,
Her
and
phone,
Mrs.
his phone, the iPad.
Yeah, everything that the police had taken back in 2018, plus he had went to the farm and gotten more devices as well.
Yeah. Did you review the Google searches obtained from Todd Mullis 76 Google account that were obtained by the state in the underlying trial?
I did.
Mr. Castle, are you aware that Todd's children took a hunter safety course?
I am.
Objection, foundation.
Overruled, the answer will remain in the record.
Why?
I would like to show the witness what has been previously marked as Exhibit 306. And just for ease of reference, this has been made into a demonstrative exhibit,
Please
exhibit
show
N
us
that
this
has been
time.
provided to the state. This is, sorry. Mr. Castle, what is this?
It is a media document containing information regarding hunter safety.
Did you review this over the course of your investigation into the Google searches?
It was one of the documents used as correlation to understand the searches that were conducted across multiple devices.
And are you familiar with this handbook and how it relates to the Google searches found on Todd Mullis' 76 Google account?
I'm going to object that on relevance, foundation, and speculation. There's been no foundation that this document specifically was used or read by anyone or when, and where this line of questioning is going is the exact same as the DVR.
Would you like to respond, counsel?
Yes, Your Honor. This document will show that the Google searches are exactly verbatim for what this hunter safety course purports in their, and with the internet searches. And trial counsel could have found this document and should have known that Todd's children had taken the hunter safety course and would have had access to this information.
Okay, and maybe that's true, but again, as far as foundation for how this witness would know how anything about this would correlate with what he did is maybe unclear at this point. So if you'd like to lay some additional foundation, you can certainly do that.
Mr. Castle, did you review Exhibit 306?
Mr. Counsel.
This document.
This document, yes, Your Honor.
I did. During the course of the investigation into the Google searches that were conducted across multiple devices, I noted a pattern that was curious in regards to, they all seem to be related to outdoor shooting activities and firearms safety. Upon further research, I discovered that there was the pattern lined up with maybe an open book test or some type of exam as it regards to the hunter safety course.
And did you review the trial testimony of Mr. Hemisap regarding this series of searches?
There seemed to be some question as to the specificity of the searches being of a violent nature, and to gain a better understanding of the pattern there, I wanted to see what came about. It revealed itself to be a series of searches regarding firearm safety and very specifically...
I'm going to object, Your Honor. This is speculation and foundation once again. This witness has not established that any particular person in the Mullis family or anywhere else has actually reviewed this document, and it's speculative.
Well, I guess I'm not sure how the witness got this information or what his investigation revealed or where he got this particular guide from. The witness can continue his answer.
Sure.
I'll just say what I said before. This isn't a good look for the Mullis team. This is the one who has to determine the trial, and she's sitting here thinking, you better make it better.
Yeah, like tighten it up. Like I'm a little confused on how relevant this is to what you're trying to.
Well, it's because there was those searches that had something to do with unaliving and snipers and stuff like that.
Yeah,
So-
like now that he said that or whatever, a pattern of like, because they would testify to violent searches. I remember that being a thing, like they were pulling up searches like this that are saying, oh, look at what he's looking at. And
Yeah,
it's
but then
actually,
they have to lay the foundation, and
I know, that's the problem.
I can just hear Bev when I look at this face. Why is the prosecutor objecting? Because he doesn't believe that Mullis's team have laid the sufficient foundation to bring in or to claim, as he does, when and what happened. Oh, look at Brandon finally getting up there.
In the course of the investigation, when I noticed that the searches conducted on multiple devices, the laptop, phone, and tablet, reflected a pattern of firearm safety, specifically, and hunting, there was a timeline that emerged that demonstrated an evening of study in regards to firearm safety and hunter safety.
Your Honor, I would like to also note for the record that the state previously indicated that they would not be objecting to foundation or authentication or identification of this particular document.
And while that is true in our preliminary objections, the court did subsequently grant good cause to the state to be excused from the foundational requirements pre-trial. And however that may be, we don't object to the foundation in that we don't need someone to come in and authenticate this document comes from whatever magazine it's from. That doesn't mean this witness has not laid the foundation for how he is aware of this exhibit or how it pertains to this case.
May I ask the witness a few follow-up questions?
You certainly may. I think he had finished his previous answer.
Thank you, Your Honor. Is this document the official study guide for the Iowa DNR hunter safety course?
Objection, foundation, leading, speculation.
It's sustained.
I actually think that she really wants this because it looks like it's a young lawyer. I think she feels kind of like, I wish I could cut you some slack. But they're just not getting there.
Why is she doing this? Like, she's not that great.
Your Honor, I would like to enter Exhibit 306 into evidence.
No, it has nothing to do with that. It has to do with there was some Google searches that was related that they, according to Jamie in the first trial, said proved he was looking up ways
Like
to
violent
analyze her.
in manner, I guess. Like,
Yeah, and if
not
someone
necessarily, yeah.
and if someone is studying where to shoot someone in the heart so they drop on the spot, because as a hunter you'll of course do the best to do a clean kill. That could be mistaken, but if they can prove that that was searched at the same time as someone was doing a hunting course, it'll change the context of the searches.
Exactly. That's what she's trying to do badly.
Again, we do not object to the foundation that this is, in fact, a magazine. I would object on relevance to this case, as no relevance has been laid.
And again, on the relevance point, I still don't have any information necessarily about specific timeframes, where this came from. I agree. I'm not seeing the relevance yet. It just hasn't been demonstrated by the evidence. If you'd like to continue to lay some foundation, you certainly can. It will not be admitted at this time.
Just one moment, Your Honor.
She got she objected, or they objected to it, and she sustained it, and then she goes, I want to admit this. And I'm like, I just thought after you paused, like, they're not going to admit it. You have to keep going.
Yeah, and I think that's why I'm saying it seems like they're not Mullis's team haven't shown up today.
No.
Yesterday, I thought we ended really positive. And
Yeah,
today
that
I'm more.
biomedical engineer was good, I thought.
Yeah, and they're really
Your
making it
Honor,
easy for the state to object.
The court may not have reviewed this yet, and I completely understand. There's a lot of documents, but there is in the record for this PCR case.
But they still have to follow the rules of evidence. And again, you are mistaken when you think that the state is out there to prove his innocence. The state believes this man is guilty. They haven't seen any new evidence, and that's why we're having this trial. So the state's job is to make sure he stays in prison because they believe he killed his wife, and a jury of 12 found him guilty of that. So the state's job isn't to sit there and say, oh, we didn't know that. Oh, that sounds interesting. Their job is to say, nope, a jury of his peers found him guilty. We see people who sits in prison for 40 years until some DNA evidence gets them out. And the state don't give a crap about it. But the state's job is not to go look for new evidence. They believe they got their man. The jury believe they got their man. It's for the defense to prove, and this is a civil case, so it's for the defense to prove beyond reasonable doubt that he needs a new trial. And the reasonable doubt is low at a civil case, I believe.
Case in the deposition of TPEM.
And they did. 12 jurors agreed with them that this guy was guilty. they did find justice. That's how the law works. I know we can then say, well, clearly they got it wrong. I do that in almost every case we watch. But the state, they have done, this guy's guilty. See you later. None of the state witnesses agree with the defense. So, again, it's their job to ruin well, not the defense. It's not the defense. It's the Mullis team. It's their job to ruin their case because they just want him to go back and live off the taxpayer dime, having someone feed him carbs and rub his back and say, do you like it? Like in the Daybell case.
It does indicate that hunter safety courses were taken.
Sadly, a long day of a very shaky Mullis team. They haven't really got, I think they have a good witness, but they can't get the answers out. And they don't have the foundation laid, so the judge keep granting the objections from the state.
And completed, it includes certificates that proves that TPE.
No, based on a defense that was ineffective of counsel. That's why we're here.
And Tristan took these courses and were certified. Additionally,
remember that it's not because they didn't prove it, it's because the defense chose a different, the wrong strategy. That's what the Mullis team is claiming.
This is the hunter safety course. It is not a magazine. It is this the study guide for this hunter safety course that the DNR utilizes. And TPEM's deposition has been admitted into evidence.
And I understand.
But they still have to get it in the right way and lay the foundation. And I think that's the problem, because she keeps saying something and the judge keeps not buying it.
I understand that, and I have reviewed that, and I am aware of that. And I don't think that that's the basis of Mr. Baki's objection. I think his point is that that information hasn't been tied to this witness. I mean, is that fair, Mr. Baki?
Yes, Your Honor.
Okay.
We certainly do not dispute that some hunter safety something was completed at some point, but it's the connection between the two.
Your Honor, may I be heard briefly?
Sure.
Mr. Hemstad's testimony at trial has specific searches, a series of searches that indicate this, that are related to the hunter safety course, and they have a specific date tied to them as they are from the Google subpoena, and so they have the actual date of the search. The certificates that also are in evidence that of the hunter safety course shows just a little bit later. There's also additional Google searches that correspond with the field day searches, which includes the follow-up to the online test that TPEM was taking on the day of the Google searches, and this is provided in her testimony. But Mr. Castle had access to the Google searches. He had access to Mr. Hemstad's testimony regarding the Google searches and his own experience on using correlative data to understand evidence and what trial counsel should have done at trial, with Todd indicating that his children had taken these.
So I think Mr. Baki's point, Ms. Steenson, is essentially that all of the factual assertions that you just made in your argument just need to be asked in the form of a question to the witness so that we can get that into the record.
Exactly.
If I'm understanding his objection correctly?
Yes, Your Honor. Okay. And I would additionally note, it just was pointed out to me that this document is also copyrighted in 2022, which, if I understand correctly, is after this trial.
So are you objecting to?
It just plays into the relevance objection, Your Honor.
Well, and so maybe this document being used as a demonstrative rather than an exhibit, and I guess I'm a little bit confused about how you're intending it to be used. You referred to it both as Exhibit 306 and also Demonstrative M. So we'll maybe need to clarify that at some point too, but I guess maybe you want to address that as well, Ms. Steenson. So,
just to clarify the record for the point that you had just asked, this is the hunter safety course is what has been previously marked as Exhibit 306. The demonstrative has certain pages from the guide included with the Google searches just for ease of reference, so it is not we're not jumping from exhibit to exhibit. So it is just to make that exam hopefully a little bit more streamlined, Your Honor.
Okay, I understand. Those are two different things.
Yes, Your Honor.
Okay. All right. Back then to the issue maybe of some additional foundation for this exhibit. Did you wish to follow up on that?
Yes, I would, Your Honor.
Okay,
Thank you.
go ahead.
Mr. Castle, did you review Mr. Hemes's testimony regarding the Google searches on Todd Mullis 76 Google account?
Not only did I review his testimony and transcript, but I also had opportunity to review the subpoena reply from Google regarding the searches conducted across multiple devices.
I agree, Rachel.
Yeah, this is such a twisty-turny case because the first
Did you
day
review,
I thought it was pulling teeth. Second day we didn't really watch it because of Karen Reed. Yesterday I thought we were doing really well, and today it just seems like someone said they were doing the $5 pitcher margarita date yesterday.
based on Mr. Hemes's testimony, the searches that were testified to in August of 2018?
I did.
And did those searches stand out to you?
Yes. The subject matter contained within those searches was interesting and curious in the means that it was discussing firearm safety, and that some of the searches conducted also referenced the Hunter Safety Guide, specifically the taking of an online test.
Have you personally taken a hunter safety course?
Objection, relevance.
Overruled.
In the state of Nebraska, I did complete and take the Hunter Safety Guide the coursework and took the test so I could become a hunter in my state. That's what gave me the understanding that some of these searches were relevant to that particular topic.
Your Honor, I'm going to lay an additional objection at this time that I'm unclear of what the scope of this expert is at this point. I believe he testified that he's a digital forensic expert, a network security consultant, and I believe he was only certified for those purposes, and now it appears that he's trying to be certified as a hunter safety expert and some sort of sociologist on what the inner workings of the Mullis family, what they're watching on TV, what they're Googling, and why, and it far exceeds the scope of this expert's background in digital forensics.
Your Honor, may I be heard, please?
You may.
Mr. Castle has demonstrated that in addition to being a digital forensic examiner with extracting data and analyzing the evidence, he also uses other evidence to examine such evidence for interpretation and investigation, and in showing how correlates and causes, how you can interpret the data. The data used at trial was solely these searches, and was very misleading without this other information surrounding these searches, and that is what Mr. Castle does as his occupation, and he is very well qualified to provide information.
And someone asked if there was new paperwork in the Karen Reed case. Yes, the defendant's motion to dismiss for extraordinary government misconduct has been filed in a redacted version, is public now, and it is on the Discord.
About what these searches mean with the corroborating evidence.
And briefly, the state likewise believes this testimony is very misleading in that this digital forensic expert is attempting to connect dots far beyond the scope of the foundation that has been laid and beyond the scope of his expertise.
Certainly the court does not consider Mr. Castle to be an expert in hunter safety. Even if he was, that is not an issue that is relevant in any way to this trial. I think we are getting off track and making this issue way more complicated than it needs to be.
Agreed.
Certainly the witness can testify about the commonly accepted practices within his area of expertise used to verify data that he extracts from devices or to interpret the data that he extracts from devices. That's where our focus needs to be, I think. And the court's not going to consider him an expert for anything beyond the areas that he is in fact an expert. So, Ms. Steenson, if you would like to ask another question, you may go ahead and do so.
Yes, Your Honor.
feel like she needs to stop taking the lead from that
I would
short-haired
like
lady, because the
to-
short-haired lady talks too much sometimes.
I would like to show the witness what has been previously admitted as Exhibit 270, and I would like to show page 3.
They were a little bit, Rachel. Because I don't believe the defense had anybody to go against it.
Do you see this exhibit?
It's waiting for the signal to come up on the screen.
I think it's because they are trying to give this lady some pitches to try and learn what she's doing, but it's just then she should shut up and not constantly because I think she's breaking her rhythm and she can't. She gets flustered. Before you go, could you tell who Julio is for me? She is a wonderful lawyer out of California who has been on a couple of times doing I had her on for my Christmas show or Christmas series about different creators, and I had her on last Saturday for Stabby Day, and she'll be on and talk about the Coburger case that she has been following, because I haven't followed that one. Everyone is always talking about that one. Hey, Jen.
Hi, Jen.
It's still not being displayed yet.
She's a personal medical,
I'm not sure,
Medical
switch devices or.
medical malpractice lawyer.
Well, just so we can see what the connectivity issue is potentially.
And Your Honor, we just discussed, since this is admitted, we're fine with this being.
Because there is some alleged Google searches that points to someone searching something violent, and they are now from Mr. Mullen's team claiming that this can be explained by the Hunter safety course.
To
Yeah.
help us all see.
Okay, 270, sure.
I also have a paper copy I can just bring up to the witness if that's all.
That's fine if you'd like, sure. I'm not sure why it's not popping up on the screen. Did you switch devices or?
Yeah.
Okay.
Yeah, the Google searches were violent in manner, and they were just basically bringing them out and saying, see, look, that kind of thing.
Yeah, and that was they found that iPad about doing something about
Mr. Castle, can you put page 3 for this exhibit?
ladies holding around in ancient times.
Yeah.
Do you see a series of searches that are dated August 7th of 2018 UTC?
At the bottom of the page, yes.
And then this continues up to searches that begin on August 9th, 2018 UTC?
Yes.
And just for the clarity of the record, do the searches go sequentially from the bottom of the page to the top of the page?
Yes.
The search dated August 9th of 2018 at 17:38 UTC. Can you tell me what that search is?
What fraction of firearm incidents occur in the home?
And based on your knowledge and understanding of UTC time, and your knowledge of, what time would this search actually have been conducted in Iowa time?
So it's in the time denoted in UTC is in military time or 24-hour time period. So it's not denoted in 12-hour time period. So it's 17:38:25 seconds. So if you subtract at this time, in August would have been daylight savings time, so 5-hour offset. So it would have been
12:38.
12:38:25 seconds.
See? I think in
So-
time
Would have been the time UTC according to that entry in this document.
And what would that be in Iowa time?
Sorry,
12:38.
in 12-hour, I just gave it to you. The
12:38.
minus 5 hours is 12:38:25.
Thank you.
That's the UTC time code stamp. The adjusted for 12-hour period would have been
12:38 p.m.
It doesn't, sorry. 1,700 hours minus 5, 12 hours, 38 Central Standard Time, daylight savings time adjusted.
Is there a search just a few moments later?
Which one specifically are you asking for?
The one just right above.
Search for examples of elbow carry of a firearm.
And what is the next search that occurs?
The search for checking for an obstruction in your firearm.
And what time is that search done?
1743.
And now I believe that the exhibit is on the screen. Do these searches continue through August 9th, 2018 at 2021 42 UTC?
They do. And as you can see from the not only just searched but visited web pages, there are references, multiple references to different states' hunter safety guides.
What indicated specifically in these searches to you that they were connected?
Thank you, Holly Mac, for 5 gifted memberships to Phoenix, Alan Jackson's Jar of Nickels, Sherry Liff, Hash Smoky Hank, and Justice Me Joe was gifted membership. Thank you so much.
The time frame in which the sites were searched and the subject matter visited subsequently. So there would be a search for a topic surrounding firearms or hunter safety, and then there would be a web page visited pertaining specifically to hunter's education.
Can you look at the Google history, same page, August 9th, 2018 at 17:44:16 UTC. Can you tell me what that website that was visited is?
You said 17 what?
17:44:16 UTC.
Visited Quizlet.com, hunter safety quiz, flashcards.
And the visited site right above that, can you tell me what that is? huntersed.com/Washington/study guide, loading and unloading steps of a firearm. And a few searches up at 17:48:52, can you tell me what that Google history is?
I'm going to object that this exhibit speaks for itself. This was admitted, I believe, as Exhibit 105A at the underlying trial, according to the sticker on the front page. The court can certainly read every search and visited site if it so chooses. The jury would have had this to the Google searches to review for themselves. I just believe under 403 this is a waste of time in the state's opinion.
Your Honor, may be heard briefly. Yep.
I'll allow the applicant to make whatever record they think is necessary. If you want to continue, Ms. Steenson, you may, so the objection is overruled.
And do these searches based on your
Read the room,
and this
lady.
Google
She's
search
getting
history
annoyed.
based on your knowledge,
Yeah,
experience,
she's
and
really
education
annoyed.
indicate that they are for a hunter safety course, people searching for answers to potential questions?
Objections beyond the expert scope. The exhibit speaks for itself.
Overruled.
Yes. The searches and subsequent visits to websites would reflect, as far as pertains to digital forensics artifacts and evidence, the viewing and searching for subject matter pertaining to hunter's education and a test therein.
So just for the record, do you find this correlative nature of the searches, starting with the first search we mentioned on August 9th, 2018 at 17:38 UTC, what fraction of firearm incidents occurred in the home, that it's related to the search of elbow carry of firearm?
I'm going to object leading.
Overruled.
The searches
She's also
as
annoyed with
reflected in this
the
document
state now.
show a pattern of a given subject surrounding firearm safety, then a visit to a web page very specifically having to do with firearms education and firearm safety.
Can you look at,
Yeah, I really like him.
He was good.
the search dated and timestamps August 9th, 2018,
Jamie, I'm gonna
17:51:53
put some food
UTC. And can you tell me what that one says?
It was a search for actions to take if one falls into cold water.
And can you tell me what the next search history is for that search?
It very specifically, you referenced the search of what action to take when one falls into cold water. There was a visited website directly after that search on boat education, what to do in falling into cold water treatments as a result of that search.
So your expert opinion, is it your expert opinion that the searches from August 9th, 1738-25 UTC through August 9th, 2018, 2021, 49 are all searches that relate to hunter safety course?
Objection, the foundation hasn't been laid for how these all connect in relevance.
Overruled.
Chronologically, in time, they show a pattern very plainly of a search for a topic, and the topic then visited of a web page that directly correlate to firearm safety, hunter's education, and survival of outdoors. The web history and searches reflect that pattern. The correlation of that data seems fairly straightforward with the evidence of these searches and web history visits.
I would like to talk about Mrs. Mullis' cell phone for a moment. Based on your review of digital forensic evidence, do you know that Mrs. Mullis created her Amy Mullis 5810 account on July 19th, 2018?
There appeared to be a new account created on Ms. Mullis' phone, as reflected by the web history, and as well as some unique dialer codes reflected in her call log.
And is it your understanding that she used this email address to solely communicate with Jerry Frazier?
Objection, foundation, irrelevance, speculation.
I would like to show the witness what has been previously admitted as exhibit, I believe 308.
Did you wish to withdraw the question or respond to the objection first?
I would like to place the foundation if that's
Okay, go ahead.
Can you pull up exhibit 308? And can you scroll to the last page? Does this exhibit show the communication between Amy Mullis and Jerry Frazier?
This document shows a number of email threads as communicated by the amyland5810@gmail.com and an email account of Jerry Frazier70@gmail.com.
Jerry Frazier.
70@gmail.com. And again, as prosecution counsel mentioned, these items are
I
truncated.
don't believe this is responsive to a pending question.
Let's have a new question, please.
Yes, Your Honor. Based on your extraction and an analysis of Mrs. Mullis's phone and her email records, did Mrs. Mullis email anyone else using the Amy Lynn 5810 Google account?
Objection, there's not foundation laid that this is every email ever sent. This is an extraction of a device, I believe, not an extraction of the Gmail account itself, unless I misunderstood.
I guess I understood it maybe the same way. Do you want to clarify that, please, counsel?
Yes, Your Honor. Mr. Castle, did you analyze Mrs. Mullis's cell phone?
I did.
Did you analyze her email address, Amy Lynn 5810 Google account?
As the artifacts or evidence was represented on her phone, yes.
Did you receive a subpoena response from the state's discovery at an underlying criminal trial of the Amy Mullis email account?
I did.
Based on your analysis of all the evidence and all the data related to the Amy Lynn 5810 @gmail account and the phone records of Amy Mullis, were you able to determine that Amy Mullis only emailed Jerry Frazier through this email address?
I'm going to object on speculation. Although I understand that that's all the data he saw, I think it's too far to say that conclusively is all the data that exists.
Your Honor, may I be heard briefly?
Objections overruled. The witness can answer if he is able.
Based on my recollection, yes, this Gmail account created by Ms. Mullis on her device was the primary modes of communication between herself and the account of Jerry Frazier 70 at gmail.com.
Okay.
Do you recall a search regarding checking the content of text messages on the phone?
I do recall that search.
I would like to publish what has been already admitted Exhibit 270 on page 7, which is the Google searches.
Oh my Lord, come on.
Come on now. Oh, and
The witnesses just
sorry,
asked for some-
while I was away, Vince Clotho also gifted 5 memberships to Charmaine Sanders, Kenny Peterson, Shanna, Chris Ladd, and Hank Brennan hashtags Alyssa.
Water, maybe if someone wants to grab, would like to grab that, thank you.
Thank you so much.
Get to it. Come on.
It's fine. Are you able to see the exhibit?
I am now.
Okay, so for the record, this is Exhibit 270, page 5. Is there a search on July 21st, 2018 at 1:43:39 UTC?
Yes, I see that entry. That entry reflects a search for checking content of text messages on a phone.
And was this search conducted in UTC time?
That is what the document reflects.
And what would that be in Iowa time?
You should have just wrote all that down.
Yeah.
Because if you're going to ask that every time.
Sorry. The 1:43:39 is the one you wanted, so it'd be 8.
8:43.
8 a.m. I would believe.
No, you don't believe. You just subtract 5. Come on now. Thank you, Big Dog, for gifting 5 memberships to Linda Early, Karen G, Nanny Goat, Shannon's Cooper, and Kim B. Thank you, Big Dog.
And this would have been on July 20th, 2018 at 8:43 p.m.
Exactly.
Sorry.
Oh my goodness.
If it's 1:43 UTC, yes, it's 8:43 local time. Just call me. I do the math in my head.
No, I believe it'd be 8 a.m. If all this is in 24-hour time period stamps.
No, it won't be AM, it'll be PM because it's 1 in the morning in England.
Then that would reflect a 1 p.m. UTC time code stamp, or minus 5 hours, 8:43 a.m. time
There's
period.
nothing called a 1 PM timestamp in UTC.
If these are all reflected in a 24-hour time clock designation.
Oh, jeepers. Now he can't even do the UTC conversion. What's going on?
So this is 1:43 a.m. UTC, so minus 6 hours would be
Oh my
8:43 p.m.,
goodness.
is that right?
Yes, I apologize for that mistake. That would be correct.
And this would have been done on the preceding day of July 20th, 2018, instead of
Yes.
July 21st, 2018?
And to correct my mistake, the 24-hour time period designation would have been in 1,300 hours for a 1 p.m. time frame, so I apologize for that mistake. Yes, that is correct.
Was there any information in the phone records you examined that corroborated this, correlated with this search?
I'm gonna object on foundation on that. This appears to be speculative.
I'm sorry, what appears to be speculative specifically?
I guess I'll withdraw the objection and see where it goes.
Okay. Do you remember the question, sir?
She was asking me if this search correlated with an evidence artifact on the phone records for this device as well.
And you may answer that question.
Yes, it did correlate to an interesting record on the as an entry on the phone record. Specifically, as a very short phone number that was an incoming artifact.
I'm still figuring out the time.
I don't know.
Well, I had time to eat before. There's nothing said.
Just one moment, Your Honor. Mr. Castle, did you review other Google searches connected to other Google accounts, such as Mullis RN Google account?
In my review of all this data, I had opportunity to review the subpoena returns for multiple Gmail accounts. And it was all taken into consideration in building my conclusions and understanding of these events, yes.
And were there similar searches on this Mullis RN at Gmail account to the search presented in Exhibit 270?
Yes.
I'm going to object. That's vague and overly broad. This is 270 is 12 pages of, I don't want to characterize a number on it, but it's a lot of searches.
Can you ask a more specific question, please, counsel?
Yes. Based on the search we just mentioned about checking the content of text messages on the phone, were there similar searches on the Mullis RN Google account that you saw during your analysis?
That's while I'm eating, so we can see as much as this trial, and then I can jump off and go get ready for the next one in like 10-15 minutes.
An examination of the forensic digital evidence in this case.
As previously stated, there were multiple accounts tied to Ms. Mullis's phone. the Mullis RN account and the Amy Mullis 5810 account being tied to the device. There were parallel searches that were conducted with these accounts tied to the device. So yes, there was overlap of the searches as conducted on this device.
Your Honor. Yes. This is, as you can tell from the people sitting at this table, we're having a little bit of a technical problem pulling the exhibits that we need for this witness. And that is obviously the fault of the attorneys, but we're having a little bit of a technical problem doing that. And I don't want to waste the court's time, and I don't want to waste the witness's time. And I'm wondering if it'd be possible for us to possibly take an earlier lunch so that we can get these exhibits pulled, so that we can move through this, so that we can move expeditiously.
Let's do that.
Your Honor.
Certainly, if you think that's the best way to use our time, we can do that. It is about 11:30 now. Are you thinking you'd want to break until 1, or should we come back a little earlier?
I think 1 will make sense, Your Honor.
Okay, let's take our lunch break. We'll plan on resuming at 1 p.m. Thank you.
Jamie, it's almost like you're planning to help me out today.
There you go.
Because then
What'd you say?
I'll set this stream for like 2:30 because that'll probably take me about an hour with you.
Yeah.
We can do that. And that's... oh, I have to do the math. It's 9:30 my time. Then. I have to deduct that.
Maybe that was just their problem, and then this will go a lot smoother. Let's just hope.
I don't think so.
Maybe.
Yes, eating will only be done on OnlyFans.
It was
I have my candy eating sessions on OnlyFans, members only, $2,500 a month. There will be a lot of chocolate spilled on my chesticles. I'm just saying. So go sign up to my OF. Buttery Baker on a Budget is my OF, where you can enjoy watching me spill food down myself and do mukbangs. Let's hope they are more prepared when they come back in the afternoon.
Yeah.
Yes, I'm running a special sale because it's February. Everyone is a little low, so $2,500 a month. Special price this month. Normal price $2,501. Jamie, I'll be jumping off. I'll be shipping everyone over to our later stream. Jamie might join us. She might not join us. She's a busy lady.
Yeah, I have some meetings, so I probably will bow out for that one and be back later.
Hopefully you'll join me and Julio in half an hour. And it'll flow better than this stream has flown today.
We're
and
fine.
If you don't want to go watch the Coburger, I'll be back at 2:30 roughly with the afternoon session in this case. Jamie, what is it Ralphie is always saying?
Pishka.
No, she says hasta la taco, Jamie.
What exhibit are you referring to?
I'm going to make this 100, Your Honor.
All right.
100. Because it is 100% correct.
So you literally built a cannon?
Yeah, it's pretty awesome.
All right, I'm in love.
Go back. Please do that again. Oh, that was the cutest thing I've ever seen.
While I'm waiting for this, did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't have cared.
You wouldn't have cared?
No.
Did you believe he had slept with your wife?
No.
Did you believe he slept with your mother-in-law?
Probably did. Everybody has.
So there.
Everybody has.